So, all right. Well, let me do a really quick introduction here. So, my name is Chris Brown. I'm happy to welcome you to the Rocky Mountain Legal AI first CLE that we've ever hosted. We are a subgroup of a larger group. What we focus on is legal issues related to AI, of course. How to use AI to solve legal problems. That's mostly for lawyers, but also non-lawyers. And then we also explore legal issues related to AI, whether it's copyright or policy or something along those lines. We exist underneath the Rocky Mountain AI Interest Group, which is a much larger group with about 3,500 members. That group meets in person once a month here in Boulder to cover all kinds of issues. I mean, literally anything from robots to education to governance and all kinds of things. Anyway, we are a subgroup of that group, and our group has four organizers. It's myself, Phil, Adrian, and Karla. And you can learn more about the four of us and our group, and you can also find our contact information at rmlegalai.org. Okay, I'm going to hand this off to Karla to introduce the program and jumpstart the conversation around Colin's presentation. Thanks, everybody.
Thank you, Chris, very much for that introduction. I'm proud to be an active participant in RMAI and its legal cohort. This group really makes it possible for us to present content by leaders in the field, like our speaker today, who is Mr. Colin Moriarty. He's a litigator and a transactional attorney who focuses on advising business clients on contract issues and resolving issues before litigation is required. He also will share a little bit more with you about his other areas of expertise and interest, which clearly one of them, which is AI. All right, Colin, we'll turn it over to you, and I will tell you more about our CLE credits, etc., at the end, so you can stick around and get that information at the end. Thank you.
Thanks so much, Karla. Yeah, my name is Colin Moriarty. I work with Moriarty Underhill. I've been litigator here in Colorado for over 20 years now. I think last I checked, 300 or so cases in the state court to my name, so been around the block. But in my prior life, I was a hobbyist computer programmer and a hobbyist cartoonist. So as soon as Stable Diffusion started hitting in about 2022, I went to the community of the business attorneys and said, guys, this is going to be huge. It took a year for people to start to listen to me, but now people do understand it. And so I've been reading, teaching, and writing about generative AI and its intersection with the law and public policy for quite some time now. And I'm very pleased and honored to be called to present here. What I want to cover here today, and I have about 2 minutes per slide, so things are going to go at lightning speed, is go through the math and mechanics of AI, because I think it's very important for people to understand what these things are they're using. And I want to go into more mathematical depth than some people you may have heard have. Then I want to go into some practical applications focused on lawyers, but some of these tools are applicable to non-lawyers as well. Then the largest part of the presentation is going to be about ethical issues, both for lawyers and also a little bit for non-lawyers. And then lastly, just some broader concerns for all users. Now, I will be going quickly. I tried to make these slides in such a way that there's a lot of citations and links to things you can look at if they interest you for further study. I think the slides are going to be available to everyone who signed up for the class. Karla and Chris can mention that at the end. But if not, feel free to take screenshots to follow up later, because we will be going very fast. So first off, the math and the mechanics. Now, an LLM, as you've probably heard in the news, is essentially a next word predictor. The genesis of this in the literature is actually really interesting. Back in the 1940s, the name escapes me, but there was a guy who did some studies with his students about taking a textbook and then making a table. And in the table, they would put all 2-word pairs that occur in the textbook. And then he started playing around with it, where he said, well, if I choose a word and I just follow a chain, this word is most associated with this next word. And that word, in turn, is associated with another word. What can I get out of that? And he would get chains of gobbledygook. But the interesting thing happened when he had chains of 3, when he found all 3 sequences of words in the book and looked through those. Suddenly you started to get little phrases that sort of made sense. And then he tried it with 4, and I don't think he went much beyond that because things got complex after that. But the point is that he started to notice that at some point you start to get what seemed like intelligible sentences. And in a big way, that's kind of what generative AI is doing. It's thinking about what the most likely next word is. The reason we haven't had it till now is because it's incomputable to do that. So if you think about the number of ways you can take all the words in a book or all the words on a web page and make 2-word pairs out of them, it's a certain size table. If you find all the ways to make 3-word combinations, it's even bigger. And if you're trying to do this for the entire English language or all languages on Earth, figuring out how many 1,000-word groups can we make becomes an incalculable problem. It gets exponentially large. So you couldn't do it just by making a table and figuring it out. There aren't enough atoms in the universe. Enter machine learning. And so I want to go through some of how we've managed to crack this nut. This deals with understanding a little bit about what machine learning is, a little bit about the secret sauce that exploded in the last couple of years based on generative pre-trained transformers that kind of makes this work. And then all the reinforcement learning that goes into it to kind of fix it after it's been created. Now, machine learning in a very small nutshell means we're going to talk a little bit of calculus, but not much. Essentially, machine learning is throwing data at a computer and having the data come up with having the computer use an algorithm that makes a guess as to some kind of equation where if you graph the equation, it matches the data, and then seeing how close it is and then automatically adjusting. It doesn't do any good to do this in the span of a human doing it by paper or by hand or even with a computer because we're too slow. You have to find a way to automate the guessing, checking, adjusting. And that's what machine learning does. So for language, for example, you take your text and put it into tokens, which are numbers, and then you have to throw it at the computer and have it make a better and better guess as to an equation that would fit it. You see on this picture here, this is a 2D equation. You have an X and a Y axis. You have a bunch of dots representing data points, and you have an equation, a line that you remember from school that fits those points kind of. That's really what's going on. But of course, when you're doing machine learning, we're not talking about 2 dimensions. We're talking about billions of dimensions. When you talk about parameters, think of them as the number of dimensions of the table we're talking about. How do you automate this? Well, that's called gradient descent. It's exciting and awesome. And if you remember calculus, it'll be even more interesting. You may have remembered in calculus that if I have an equation for a line, I can figure out the slope, meaning where the line's going, at any point in the line using a derivative. If you don't remember that, look it up. It's super cool. And a derivative can be found automatically. It doesn't require a human. And the fun thing is, if you've thrown your data at a computer and the computer has produced an equation that gives you a guess that's sort of close to it, and you want to tell the computer how to adjust it automatically, well, the computer's got to know which way to go. I'm simplifying here, but it's got to know how to adjust the parameters up or down to try to make its next guess better. Well, if you have a line that's sloped this way and you test what the error is, how far away the guess is from the data, and you look at the slope of that error function, the slope will tell you whether you're going up or you're going down. Okay, go down. In other words, you figure out the error function, you automatically find the slope, and that tells the computer how to tweak what it did to get a little better. Do that millions, billions of times in a row, and you end up with a shape that gradually starts to match the data, gets very good at predicting the data. And importantly, no one had to figure out by hand what that equation was. Nobody had to program it. They just had to program the algorithm that kind of grows it automatically. Scale this up to more dimensions, and what you end up with is a multi-dimensional model. You'll hear the word model a lot. I think of a model as just being a shape. Think of this eldritch billion-dimensional shape, incomprehensible, but all the little details of the shape show you how it functions. And so here you'll see pictures. I use 3 dimensions to show you we're going beyond 2, but really this shape is far more complex than that. But that's not the end of it, because so what? You've machine learned on the data. How do you ask questions of the data? Well, you need to be able, if you remember your math again, you need to have an input for your function. You need to somehow reduce what you want to start with into a data point that you can feed in. And then the function tells you, okay, for this X, here's the Y. Or in this case, here's the Y, Z, A, B, whatever parameter we get as a result. And the magic that's made things happen now is a thing called the generative pre-trained transformer. You take all human language, you break it up using machine learning itself into little token chunks that are represented by numbers. And then the GPT's job is to look at all those numbers in all the prompting, in all the book that you uploaded, in all the internet, and figure out how to compress that into a single number. Now, I say number, it's actually a vector, it's a series of numbers. But the point is, you have to compress it into a single input. And that's kind of what happens here. When you ask a question of a LLM, a large language model, you are be giving it a bunch of text, which gets compressed into a single vector through a GPT. Then that is used as input into this giant eldritch multidimensional function, and out comes the next token. That token then goes back into adjusting that original vector because now the meaning has changed, and you repeat the process. Now, this is phenomenal, and I don't have a link here to it, but what this means is that you take all of human language and you're embedding it in a vector space based on what the numbers are, and you can play with this. There's websites that let you check, and for bias purposes, this might be really interesting for people. What words are close to other words and what words cause the vector to change in what way? It's amazing stuff. But the important thing to remember is that when you talk to an LLM, you are taking text, reducing it to a number, putting it into a function that's represented by a shape, and then out comes another number. That's all that's happening. When you first create these things through machine learning, these shapes, they're what we call unaligned. So they're very good at predicting the next word, but it turns out that most of the time, that's not really all we want them to do. We want them to be useful. We want them to be truthful. We want them to be not profane, things like that. And so after you've done your work in creating this giant model, and when you hear about people training a model for years and years and years, this is most of the work. Now we want to align it. So now they do other things where they try to use humans to look at the output and adjust what, give rewards or negative feedback, just like going up or down on a slope, to change the shape, to squeeze it into a different shape that makes it more likely to produce aligned output that we want. And the way they do this is really interesting because remember, humans are slow. We can't provide input anywhere near quickly enough for the LLM to do its job. So instead, what they'll do is they'll have a whole nother machine learning AI that pings the humans, people who are hired on a gig economy basis, to review and rate responses from the LLM you're actually training. So you got the training LLM, intermediate LLM, and a human. And that intermediate LLM looks at what the human likes and doesn't like and trains itself to predict what the human's going to like and not like, and then trains the eventual model on that. And so it turns out that for every input the human gives it, the intermediate model is training like 1,000,000 more times on that input, which allows you to scale up quickly enough to get these models trained. And once you get all that done, once you've massaged the shape into some useful thing, you're still not done because you want to put it into a broader system that allows people in the world to interact with it. If you've ever played with a raw LLM, and you can go download software called LLM Studio, which is fantastic for this. It'll handle the download of all the model off of a website called Hugging Face, which is awesome. It'll handle running it for you locally if your computer can handle it. It's great. But if you play with these models locally, what you quickly realize is giving it raw input can cause all sorts of weird results. If you remember early in the LLM era, you had all sorts of stories about reporters talking to models, and they go nuts. They say weird things. A lot of that's because the more you're interacting with the raw model, the more you realize how strange and unpredictable it is. Well, providers don't like that. They want to provide a consistent experience. So they tend to never give you direct access to the LLM. When you go to ChatGPT or Claude or whatever, you're not talking to the LLM, you're talking to a piece of software, which then tries to add more pre-prompting to your request, and then probably uses another LLM to adjust the prompt a little bit. And it kind of bounces around internally for a while before you ever get to the underlying system. And this allows them to do all sorts of things, not only make more consistent output for you, but they can also monitor. They can see what you're giving it and flag things that are inappropriate. They can see what's coming out, and so they can flag it as improper. One fun example was people about a year and a half ago, noticed that ChatGPT had a really hard time reciting Dune's Liturgy Against Fear, which is a fun sci-fi thing. And people had all sorts of theories for why that would be the case. But it wasn't that complicated. It was just that ChatGPT had realized, based on all the lawsuits, that they better be able to show courts they're trying to stop their model from producing copyrighted works. And so a piece of software sitting above the model would notice that it's copyrighted and step in to stop the output. So you're almost never going to work with a raw model unless you're doing it locally. You're working with someone's package around it. Now, anyhow you interact with the model, you have to be aware of a few things. These are more or less true as we do more and more of this kind of packaging in safeguards. But you have to remember that the model is no context, it has no common sense. Do not personify it. Remember, if you must think of it as an entity that thinks at all, it is completely alien from any human being. It is just a multidimensional shape. So it'll answer questions weirdly. It will miss things that would be obvious to a human. One fun example I saw at one point was talking about an image on a computer screen, and there was a prompt to the LLM that was something along the lines of, how big would I have to make the image on the screen so someone could see it at the other side of a football field? Now, a human would know, well, wait a minute, the screen only has a certain size. So there's a limit implied by the facts. But the model wouldn't know that. So the model says, oh, it'd have to be as big as the stadium or something, even though the screen itself has been specified. And of course, you get these hallucinations and things too, because it's not trained for truth. It's not growing up in reality, although maybe we'll get there. It's not doing testing in the world like a human would as it grows. It's just training on this data. Also, you have to remember that the LLM is going to be limited by its training data. What that means is that if the model didn't train on something, whether or not it will generalize to it is uncertain. So the results you get might or might not be accurate. And I linked here to Anthropic because they are the people that are doing the most, as I can see, to try to make the research on interpreting what exactly the model's doing in an accessible way. I think that's extremely important. And follow that website if you're interested in learning more about the mechanics of how an LLM thinks. From your perspective as a user, because the model is just trying to match text, that means it's going to be garbage in, garbage out. It's going to kind of match what you give it. This little graphic here, you can see if you give it something that sounds like a 13-year-old gamer yelling at mom, you are likely to get output that's like that. Again, this becomes less true as we go on and people package it in software that insulates the model from how you speak. And a lot of the stuff that is available for lawyers and business owners has its own packaging that really endeavors to try to change your prompt into something that they've found is more useful way of phrasing it. But in general, you want to write like the source that you want to emulate. Early on, people found think step by step or things like that are important. And the reason that that is important is because those are the kind of words that you would see in a book that was written about the subject in a way that you actually, something you would consult, you know? And so you want to be careful in how you're asking questions so that the model gives you something that you actually want. I'll skip the prompt injection thing for now for time purposes, but this also leads to the possibility of people putting information in to get bad results without you knowing about it. Whole different story. If the model has seen a problem in the training data, if it's seen examples of it, you will be very impressed with its output. It's very good at search. It's very good at things like that. Common forms and contracts. It can be very helpful there. And if it's the sort of thing where a Google search, would solve the problem, you will also be impressed because to the extent that it's absorbed all this data, and many models have access to the internet anyway, it will do a very good job. This also leads to some problems for memorization, but this is more of a copyright issue. And for time, again, I'll skip that for now. In the law, what does this mean it's good for? Well, I think that the primary purpose of AI that we're going to see here continue to roll out is basically a human interface device. If you remember Star Trek, they talked to their computer, and the computers weren't all that smart on the ship, but they could give it instructions and ask it things in common language. I'm still blown away by the fact we can do that now. We've had the tricorders, in our pockets for a long time, the communicators, but now we can just talk to our computer. And I think this is really the key factor. And for us as lawyers, this skips ahead a bit, but that means we have another way of searching, whether we're uploading a database of documents we want to search, or whether we're just looking on Lexis and Westlaw. You always had the right to search by terms and connectors or plain language. Now we have another tool, which is to ask it in the form of a regular human language. That's awesome. But it's also good for drafting, editing, and even proofreading, looking for errors in it. You can use it to generate a lot of text, and you can use it as a good starting point. You can use it to brainstorm. One of the best cases is just bouncing ideas off the LLM. There's a lot of lawyers on YouTube who talk about how to use LLM in their practice. And one of the common threads they always talk about is, going to the model and explaining the situation and asking it for input. In other words, don't ask it to write a letter. tell it what the situation is, and ask it for what kind of questions it would think to ask. The important thing is that it's being used to trigger your own training as a lawyer, more so than generating something from scratch. And there's some other interesting things you can do with it as well. Now, when you're out there as a lawyer looking, there's a lot of people who want to sell you stuff. Some of them I've tried, some of them I haven't. I will let you guys know that on February 27th, so mark your calendars, the Colorado Bar Association is doing a symposium for a full day on practical applications of AI for lawyers. I'm on the panel that's talking, and I'm really pushing people to not talk in the abstract, but talk specifics. And that also means specific products. And I happen to know someone going there from one of the larger firms apparently has done reviews of about 500 different products. So if you're interested at all, I would strongly recommend you sign up for that. But in general, you have several things you could use, and I want to touch on some of them. So first off, there's your legacy legal research services like Lexis and Westlaw. They both have AI tools at this point, and they tend to use them for helping you with the search. What I find them useful for myself is I will open a tab and ask my research question to the AI, and then move that tab off to the side, and then do my own normal research in a different window. And then as the AI is doing its thing, I can bounce back and forth. And this is a very productive way to find stuff. I would say that the results from the AI are useful probably a third to a fourth of the time, but that's still some advantage because it's just a different way of interfacing with the database. If you want to use any of the public models, such as ChatGPT and Claude, and again, some attorneys think they're great, make sure you're trying to use the enterprise versions, and make sure, as we'll go into in the future, that you've tweaked the settings to preserve confidentiality. This is extremely important. Also be aware that whether you like it or not, AI is being shoved into the throats of your computers and all your staff. Both Word and Adobe are the big offenders. They both have little AI buttons that's easy to check, where if you push them, AI is going to review your PDF or review your Word document, and that means it's going to a model somewhere. So be aware that whether you like it or not, your staff need to be aware of it. And then there's other more lawyer-specific tools. I've heard good things about General Counsel AI. Spellbook has gotten some good reviews. Alexi has as well. I know some people like this program called Harvey. Remember that all of these, for the most part, as far as I can tell, so don't quote me on this, are all just more wrappers around either Claude or ChatGPT or Gemini. And it's other people helping put software in place that basically helps you interface with those devices. So if you're looking for these people to use in your practice, ask them that, because they may or may not be super helpful depending upon how skilled you are at prompting. If you don't need the extra help, you might be able to save yourself some money by just using the big tools that these vendors are using anyway. There are, at this point, some ethical issues with generative AI, and this is where you're getting credit, so we're going to spend a lot of time on this. When you are using generative AI, there's three big issues to worry about. If you're not a lawyer, beware of the unauthorized practice of law, which you can get into very quickly. If you are a lawyer, you have to worry about how the rules of professional conduct intersect with it. And whether you're a lawyer or not, you have to think about the legal and broader moral issues that are involved, which we'll probably have very little time to talk about today, but we'll talk about a little bit. So first off, if you're not a lawyer and you're using AI, be aware about the rules against the unauthorized practice of law. Our rules define the unauthorized practice of law specifically to include owning or controlling a website, application, software, bot, or other technology that interactively offers or provides services involving the exercise of legal judgment. So if you have this great idea for a startup where you're going to have robo-lawyer, and you've heard about this in the news, that very well may violate the unauthorized practice of law. Now, this doesn't apply if you're using it to help yourself necessarily, although the provider of the LLM might potentially be liable depending upon what they're doing. But if you're a pro se litigant using it in your own case, you're not committing the unauthorized practice of law. But if you're a husband using it to write things for your wife, you might be. If you're a business owner trying to use it to represent your business, you might be. If you're a licensed professional, you might have kind of an out here. So there's a case called Conway Bogey, which deals with a real estate licensed professional. And what the Colorado Supreme Court said in that case was, yes, we see that the real estate person is basically practicing law when they provide contracts. and they tell their customers what to do on a real estate deal. But that's going to be okay because they're separately licensed. So as long as they stay within certain parameters for their real estate license, we're kind of going to let them get away with it, even though it is technically an unauthorized practice of law. And they've also shown some desire to expand legal representation to non-lawyers in other ways. Like a couple of years back, they allowed paraprofessionals to represent people in domestic cases like divorces. And there's a lot of people who are on the access to justice side of things that are pushing for more stuff like this to let non-lawyers help, litigants out. But basically, if you don't have a license of some other kind to do what you're doing, you should think very carefully before using an LLM to advise anyone other than yourself. As to lawyers, we have the Colorado Rules of Professional Conduct. Now, I think it's on Thursday at 3:30. This proposed rule on the screen is going to be up for discussion in front of the Supreme Court. It's a webinar thing. You can tune in if you want. Comment has closed, so if you feel strongly about it, you're too late. But this may well be the law in a couple of days. And essentially what they did is they formed a committee to say, do we have to update the rules of professional conduct? And they decided not really. And they basically added some comments that just make it clear that whether or not a lawyer is using AI, all these rules still apply. And we'll get to these in a minute. But stay tuned because this will either be the law in a few days or something very similar will be. The first duty that's really implicated by the use of AI is the duty of competence. We as lawyers have seen new tools arise during our lifetime. Some of us are older and remember when fax machines got replaced by email. People my age saw things all go to the cloud. Now we're seeing people use AI. You have a duty as a lawyer to be competent in the use of the tools that help your client or could help your client. You need to make sure you understand how the technology works and how it can help your client. Just like you wouldn't tell a client that you refuse to communicate by email anymore, you probably are getting to the point where you can't tell the client that you don't use AI or won't. That's even more because, as I said, a lot of the software we use anyway is having AI shoved into it. How competent do you need to be exactly? Well, the best analogy I heard from one of the judges, and this I think was from the Democracy Summit in October of 23, was you have to be as competent in using these tools as you are in driving your car. So you don't have to be able to necessarily build it from scratch, but it would be nice to know how the brake works, right? And so you really should look into how other people have commented on it. You have the Colorado judges who've talked about this. There's a couple of ethics opinions. The Colorado Bar Association is thinking about an ethics opinion. And there's a panel being formed that I'm on where we're going to come up with some guidelines for lawyers, hopefully. But right now, there isn't anything other than these proposed rules and some sources from other states. But do stay tuned because more stuff will come down the pipe. Be aware of them as they arrive because they will help you understand how to properly use these tools in a safe way. The second, and this is the most inexplicable rule that people are violating and getting in trouble for, is diligence and candor. As a lawyer, you are not supposed to make a false statement of fact to a tribunal. You're not supposed to tell it a case exists when it doesn't. You are also not supposed to do anything engaging in dishonesty, deceit, or misrepresentation. And when you sign a brief, your signature says that you have read it and to the best of your knowledge, information, and belief, formed after a reasonable inquiry, it is well grounded in fact and warranted by existing law. So this is the stuff that you read about in the news that keeps getting attorneys in trouble because they submit things to the court the LLM produced without checking, and they end up making a false statement about a case. This duty that you have to make sure that what is being submitted to the court is truthful extends to your subordinates, whether they're humans or not, because the rules are very clear that a supervising lawyer has to make reasonable efforts to make sure that everyone under them is complying with the rules of professional conduct. I referenced earlier that these tools are in stuff, whether you want them or not. And I guarantee you that if anyone on your staff thinks they can cut corners or get things done more quickly by using AI and they have access to it, they're very tempted to do it. So it's extremely important, in my view, that you have in your policy manual in your practice guides, whatever you use in your firm, that you have guidelines for the use of AI, whether you allow it or don't. And I think that telling people they can't use it at all is probably going to not be effective, because if people are told not to use it, they're likely to use it anyway, either accidentally or because it makes their life easier. And the difference is you're just not going to know about it. So remember that you're responsible for what other people do. Now, if things do slip through to the court that are false, there will be sanctions. There will be something to do about it. There are 3 cases here on this page, and this number has to be updated now. We're well over 600 at this point of cases where people have been sanctioned or faced other negative consequences because they put hallucinations into the court record. Here, one of the big ones, the first one you've heard about, was Mata v. Avanaka. That's the New York case. I go into great depth in this on one of my first articles for the Colorado Lawyer. And if you really want to find all the amusing tidbits and laugh at some other attorney, go ahead and read it. But understand that, it could be you if you're not paying attention either. This lawyer, for example, was on the stand in the sanctions hearing and was asked what F2D stood for, and he didn't know. He didn't know federal second. All right. This is a problem that I think comes in more and more as we get away from the books. And if I can get on my soapbox for a minute here, those of us who went to law school about 21 years ago may have been the last generation that actually had their legal research and writing in a library with real books. After that, because the practice of law has moved on to online research, they don't do it anymore, I'm told. Schools just use the online tools. This is fine, it's efficient, but there's a problem. The law is still organized and still cited using the way that it was designed in the books. The Federal Reporters, the Pacific Reporters, the ones we care about, the AmJur, the CJS, like all those things are still how everything's organized. And so when you're using the online tools like Lexis and Westlaw, if you don't have a good understanding of the structure of the organization behind things, when you're doing your research, you just treat it like Google, you can get into trouble with or without AI. But the AI makes it a lot worse. Recently, here in this, we had the first person in the country who was sanctioned by a bar association. The unfortunate attorney, Mr. Krabill, got in trouble back in 2023. In his case, what had happened is he was a former prosecutor who was entering into a new area of law. I think it was domestic, but it was certainly civil. And he used LLM to help him draft a brief in front of Judge Bentley down in the Springs. He did discover that he had a hallucination. He came clean to the court very quickly. Judge Bentley referred him to the Bar Association, and he ended up getting sanctioned. Since then, I believe what he's done, I haven't checked recently, but last year he had formed a firm that was really trying to lean into the publicity, saying we're an AI-powered firm. So best of luck to him. But suffice to say, putting the information in the court record by itself, even if you then retract it, can be problematic. And here again, soapbox issue. It's more than just misleading the court. All these research tools that we use, Lexis, Westlaw, they have these huge databases of things. And it's not just appellate authority anymore. They will go and grab state court decisions as well. And this is a problem when I'm training junior associates on research, because they'll find a case that's on point. And I have to say, okay, but that's a district court level case at the state level from some other jurisdiction. This, you can look at it, but it doesn't really have any presidential value. Don't cite it. Because everything's being gobbled up by these databases, if briefs too can be gobbled up. So even if the court doesn't cite your fake case might starting to be injected into the research system, which has consequences for future training. It has consequences for people reading the brief and being misled. So there's a corrosive effect of all these hallucinations on the industry in a big way. And I think this is why judges are extremely correct to be very harsh with people who let this get into the record somehow. And then there's one case in our federal district court, Deganey v. Castro, where again, somebody said to the court that they outsourced their site checking to someone else who didn't do a good job. So hallucinated cases slipped on through and they got in trouble too. If you want to keep an eye on what the clown car count is, there's a website that I've found. There's a bunch of them, but Damian Charlatan's tracker seems to be the most comprehensive. So keep an eye on that if you're interested. In all the cases where attorneys get in trouble, the problem isn't the AI itself. The problem is people didn't check their citations. So in some respect, what we're seeing here is pulling the cloth off of people who weren't probably doing a very good job to begin with, either because they are overworked or because they don't understand whose responsibility it is or something like that. And I quoted on this page a bunch of quotes from judges in the 10th Circuit that say in a far more eloquent way what I'm saying here. I particularly like the judge in Maddox that talks about the ruling's not about technology, it's about trust. And I love this bit. Language draws its power from the hearts and minds that create it. Words alone are empty until filled with human conviction. Very flowery way of saying, check your citations. Apologies for that. If you want to avoid being a cautionary tale, just check your citations. But like I said before, there's a lot of reasons people don't. One of the early ones, and hopefully one that no one listening to this seminar will fall into, is credibility of the output. One of the things you'll learn as an attorney hiring people is that if they write really well and their writing is very organized and the punctuation's in the right place and it's all very easy to follow and all that, you have higher trust for them because you figure that along the way of learning to write that well, they've developed the other skills they need too. That's not true with LLM. They are very, very, very good at actually putting the words together. That's their whole existence. So you can have borrowed credibility sometimes where the result seems very strong. The result seems very credible because of how it's written. But you have to disregard that when you're talking to an LLM. The way that it speaks has nothing to do with the truthfulness of its output. Lack of experience as well, people that don't realize that AI can hallucinate. Again, getting rarer, I hope, as time goes on, but that ticker of cases where people keep sanctioning gets higher and higher. So people still haven't got the message. Another common thread in these cases, and there's one case where Trump's lawyer, what's his name? Cohen, got sanctioned a while back. There's another case where I think the My Pillow guy's attorneys got sanctioned, if I remember correctly. And my understanding in both of those cases is you had several cooks in the kitchen, several lawyers writing the brief, and each one basically thought the other person was checking the citation. So if you're not clear on exactly who it is that's in charge of checking your citations, that can be a problem too. I've also seen recent cases in our jurisdiction where they hire attorney says, well, I told the junior associate to check the cites, and they didn't. They just used the LLM. Doesn't matter. You're still responsible. And then, of course, there's simple inattention. I tend to have typos in my brief. Other people can too. If you're dealing with an LLM, the typo can be far worse than just dropping a period or saying F second when you meant F third. It can be a whole made up case. Okay. And of course, you probably don't need to be told, but checking citations has other benefits. You can't argue what you don't understand. And so having understood the cases will help you be a lawyer. One other thing to reference here is it's not always just the false hallucinations that'll get you in trouble. And if you've ever messed with Lexis or Westlaw's AI, you can see this sometimes. Sometimes the LLM will give you a truthful response, but the response is not really exactly what you're looking for. It's a strange abstraction from some other area of law. Like if you ask a question that doesn't have a clear answer, it will sometimes latch on to similar language in an unrelated field and barf that out. So it's not enough to make sure the citations are correct. If you actually want to do a good job as a lawyer, you have to apply your own reasoning. You can't do this as a first year who is just using it to make up for the fact that you don't have a lot of experience. You need a human mentor so far to make this work. And if you're pro se, you're not safe. Now, we have the first case in the country sanctioning a lawyer, like I said. We also have the first case in the country sanctioning a pro se person. This was El Hamim. In this case, a pro se litigant was using LLM to dump hallucinated stuff in the record, and the Court of Appeals said, we're not going to sanction you this time, but next time it happens, you are all on notice that you can be sanctioned. This has also happened in the federal court. As a lawyer who deals with both, large companies and small issues, I have seen a lot of pro se people use this stuff. I have my own thoughts on it, which not entirely positive, because what I do tend to see is people, once they have that magic box that they can use to produce a lot of text, they produce a lot of text. And they should be aware that either hallucinations or just wasting everybody's time. There's one guy who filed 70 pleadings in a month. using an LLM, this kind of stuff can and sometimes will get you sanctioned. Now, I think district court judges, your mileage may vary, are very understanding about pro se people. They're still feeling it out, but be careful on litigating this way yourself without a lawyer. And also make very certain to check standing orders. Mostly the state court judges will do this in their delay reduction order or their initial order in the case. They'll tell you if they've got an AI rule. At the federal level, they won't necessarily. They require you to go read their standing orders. But some judges have specific requirements that you disclose stuff. And at the bottom of this slide, I linked to a tracker at the federal level. But there isn't such a tracker at the state level. So read your DROs very carefully. I know, for example, I just got one in Arapahoe County where the judge has added a clause that says, if you used AI at all in the writing of this, you have to say you did so, and you should certify that you checked the citations. The next big problem with using LLMs is confidentiality. Now, here's a quick question. If you use Google to go research your client or the other party or to ask a general question, is your Google query privileged? Is it kept confidential? You'll be surprised to know that I can't find an answer to that question. We've all kind of accepted the use of email and Google search and all that, but there isn't really a lot of good authority on whether or not that's protected. When you're talking to an LLM, it's not that much different. You're taking information and you're shooting it off to a third party. This implicates at least 3 rules and statutes that are related, but not quite the same. You have different duties. So first off, you have the ethics rule of confidentiality. This says a lawyer shall not reveal information relating to the representation of a client unless the client gives consent or the disclosure is impliedly authorized or for some other reasons. I think when most of us do research, we understand it's impliedly authorized. And if you're doing something that's normal and accepted and people do every day, your argument might be stronger. But the more you go into newer technologies and untested vendors, maybe you drift away from that. And bear in mind here that this is not limited to privileged information. Confidentiality covers all information relating to the representation of a client without limitation. The privilege is a statutory issue that says that you can't be examined without your client's consent on communication for the purpose of legal advice. That's a whole different issue. And then you have work product, which you may have heard about. And work product is not either one of those things. Work product is a discovery limitation that says that the work you do preparing for a case, I'm paraphrasing, isn't itself discovery in that case most of the time. These 3 rules are different. They apply in different situations. And use of an LLM implicates all of them. Because when you write your prompt, if you have client data in that prompt, you are sending it out to the web to be used by a third-party data center to process a response and produce it back to you. If you are using the wrong vendor and using the wrong settings, that vendor is constantly using user input to update the model, to make it better. That whole human reinforcement part of the process, yeah, that never stops. They keep on doing that as the model is live. So if you're not careful, the model may be ingesting your data. What that means is if you're unlucky, that data might be recoverable by someone else, because think of it as an imprint in the model. Everything that is prompted that actually goes into training leaves a little bit of a divot in that giant shape. And if you're unlucky enough that that gets reinforced, other people might be able to produce it back out. Now, of course, big providers are trying to protect against that with all their surrounding software and other techniques, but the risk remains. And the mere fact that it's been exposed to a third party in some way may be enough, in the case of privilege at least, to break the privilege. Other places you have to worry about, especially when you're using these online models on the web like ChatGPT, is whether your prompts are being stored. So in the New York Times lawsuit they have against OpenAI, they're fighting still over an order about OpenAI wanting to delete the past prompts to protect people's privacy and confidentiality. And the New York Times saying, no, we want an order, an injunction stopping you from doing that. We want to preserve all those prompts for discovery because we want to prove that you're violating the copyright of the New York Times. So if you prompt them, you might delete them locally. Are they being deleted at all? And you may be subject to court challenges on this, because even if the information you give the LLM is not accessible by anyone else, once you have actually given it to the LLM, are you still entitled to protect it? Don't really know yet. In order to protect the confidentiality, you have to do a couple of things. Number one, whatever LLM you're using, read the terms, the user end license agreement, the privacy statement, all that kind of stuff. Know exactly what it is they do and don't do. Last I checked, I don't know if it's still true, Adobe's terms and conditions sort of say anything you use for AI through Adobe becomes their property to train on. That's no bueno for legal stuff. Number two, if you're going to use a tool, look for the settings that let you opt out of any ingestion or training. OpenAI has a setting where you go in and say, make the model better. Tell it, no, we don't want any of that. Don't make it any better. And also get rid of all the stuff that says they're going to store it. If you can afford it, a locally run model where you download the weights to your own computers and run it is great, but that's very expensive. And having spent a lot of time trying to run it myself on consumer grade computers, it's really not worth it. It doesn't help you at all unless you're using the big boy models. When you're hiring vendors, hire well-respected vendors. This space is very new. Lexis and Westlaw, you can probably trust that they know what they're doing when it comes to data privacy. Some of these other outfits, especially ones that aren't legally specific, you don't know how much to trust them. You don't know if they're going to have a data breach or not. This will change over time, but understand that it's a risk. And the last thing is, the reason the internet works at all, the reason you don't get subpoenas for your Google searches all the time, is mostly because of something called the Stored Communications Act that allows providers online that get information from users to protect it from virtually everybody, including even subpoenas from the US government. And so this may or may not, I haven't seen a case yet applying it to OpenAI or Gemini, but it may apply and it may offer some protection. But it's worth being up to speed on that as you think about using it. Another thing attorneys have to worry about using models is bias and prejudice. Rule 8.4 says it's professional misconduct to engage in conduct that appeals to or engage in discrimination against people for various reasons. Now, in reality, as far as I can tell, the only time people have gotten in trouble for this so far is when they're caught in an email or in the hallway using a racial slur or a homophobic comment to describe a judge or opposing counsel, and someone overhears it and they get in trouble. So the kind of subtle biases that AI may bring into this may or may not get you in trouble, but you do still have a rule to deal with. And I don't know if I put it in the slides or not. Let me check. I didn't. The AI law that was passed a couple of years back in Colorado does also specifically apply to the use of models to determine who gets legal services. So be aware that you may have some obligations to the state whenever that law actually goes into effect to show that the model you're using for client intake, for example, has been tested and doesn't discriminate on the basis of protected class. When a model discriminates, it's not as overt as sort of like a human discriminating. It's discrimination born from the way words are associated. Models are easily misled by syntax and missing the context. This, again, is something they're trying to get better on over time. But be very careful with the way you phrase your prompts, because if your prompt sounds like a common joke or a common puzzle or a common fact pattern in a case, then you may bring a lot of biases embedded in that case along for the ride. To avoid these bias issues, I would recommend you use a trusted provider. You want to find someone who's been working hard to leverage training to get more objective results and try to get away from the bias. Your prompt should be neutral and detailed, because again, if your prompt has kind of like charged emotional gender-based language in it, you're probably going to see that in your output, garbage in, garbage out. When you're prompting, you want to always be adversarial with it. When you get a result, say, is this true? Is that right? Double check, think about it more, force more self-review. And then, of course, yourself, nothing accounts for you as the attorney, just like checking your cites. Check your privilege. Make sure that you understand what's potentially a bias issue in the real world. Another issue that applies to both lawyers and non-lawyers is whether generative AI is going to stay legal at all. Now, here, there's a ton of cases going on all over the country and in some other countries about whether or not AI violates copyright law. That's the biggest issue. There's some other things, that's the biggest one. And generally, these cases pit content creators or those who sponsor them, like the record industry, against the people who create these LLM models. And the major flashpoints right now are on whether or not what they're doing when they copy all the data, because they have to start with a bunch of data to do that machine learning. They get that online. They may not get it online by buying it legitimately, And so is that itself a problem? Probably, maybe. And then the big issue is fair use. And these decisions are coming out fast and furious, but fair use seems to be the key point. Generally speaking, if you take someone else's work and you are sufficiently transformative, whatever that means, there's four elements that people can't agree on, then your result, isn't an infringement anymore. It's a new product. I think that right now there's a case where Google, Amazon won this on the issue of creating databases of thumbnails for people's images for web search, or creating a database of searchable text from a library that people are relying on a lot. And it seems likely that the LLM people are going to provide and win on those. But you don't know. So these tools might change or be improper. What definitely is going on is that some of these cases have issued orders basically suggesting the LLM provider may or may not be liable for infringing output, depending upon the effort and the guardrails that it put up. So you're going to constantly see changes and updates to all these tools as the providers incorporate more and more guardrails to protect them from potential litigation. The USPTO, the Patent and Trademark Office, has a series of discussions about this, part 1, part 2, part 3. Highly recommend reading them. It's just the agency's opinion, and I'm not sure how much that matters anymore in this age now after the Supreme Court got rid of some of its deference. But it's a wonderful resource that compiles the law on this and generally says, you might be transformative, you might not be, but if you source your data in a way that's objectionable, you might be in trouble. So some of these vendors might change or go away. Oh, and the last thing, you see sometimes some of these larger providers like the RAIA or Disney cutting deals with some of these LLMs or other generative AI providers. And that may happen more in the future too. I'm extremely worried about that leading to more advertisements in the AI, but that's a different question. If you use the AI to create something, on the flip side here of whether you're infringing on someone else's copyright is whether you have any rights to it whatsoever. And the USPTO and cases seem to be suggesting probably not. If you just prompt the LLM and get a result, you have created something that's probably public domain because you didn't put any human ingenuity into it. You just described the prompt. Those who are prompt engineers will be yelling at me now, and I'm sorry, but that is how it is. Currently, it appears that from a legal perspective, if you want protection in your output, you have to show that you've done sufficient amount of work to it after it was produced by the LLM in order, or whatever it was, image generator, Sora, whatever, nano banana, in order to make it something that truly can be copyrightable. Again, this is going to have a lot of changes in the law coming up, but if you're busy producing content for your website, for example, or if you have a blog out there and you're hiring someone to do blog posts for you, very unlikely they're not using AI in some way, and that may be problematic. Then finally, there's some ethical and moral issues that apply more broadly than all these things we've talked about. And this discussion is way beyond this class, but I am doing a class on January 23rd at the Denver History Museum through the Bar Association, where they've asked me to dive into these things in a lot more detail. So if you're interested, you can go sign up for that too. Some of these involve disruption of employment. Data is really hard to come by. Most of the research you read on this is people speculating about maybe what the LLM or other technology can be used for, and maybe how many people are disrupted. So it's hard to find exact numbers, but it definitely is impacting people. Companies in the last couple of years have fired people to replace them in part with AI and supervisors for the AI. There are a lot of people in the gig economy, especially translators, who have seen their income drop enormously as a result, as you'd predict. For artwork, we've seen the same kind of drop. I think, I forget the art studio online thing that had some data on this, but essentially it was showing a vast increase in output after AI when it came to art, which makes sense. And supply and demand means that even if you can still get a paid for your art, you're going to not be able to charge as much when there's more out there. For lawyers and non-lawyers, there's a temptation to rely on the AI rather than hiring new lawyers. And this is a huge problem because you're mortgaging away your future if you do that. If you decide to use an LLM to help you instead of hire a junior associate to train, in addition to all the important mammalian commonality and camaraderie that comes with working with a human being, which is good too, You don't have anyone who's going to buy your firm when you want to retire. You need to help train the next generation. We all have that duty. There's also issues of consolidation of power. To the extent that AI is effective in handling work that other people could do, it helps consolidate power at the top of the pyramid, because there's fewer people down below they have to rely on. There are environmental costs. It uses a lot of water, and it's not so much the amount of water it uses. We use way more for corn than we do for AI. But technically, I think most AI places I've heard of are using water that comes from the municipal system, like cleaned water, because it's going into a computer and a cooling system, rather than kind of the non-potable water that most other industrial uses use. So it has an impact. And then, of course, there's the existential threat. And if you're into that, that AI may kill us all I'll say is go read Yokowski's book. It's a spooky read. And he's not wrong at all, but it's very, very, very unclear how close we are to those kind of risks. All you have to worry about at this point, I think, is don't think of these risks as pretend. They are real. And the reason you can understand that is you don't have to have a system that's intelligent or smart or conscious in order to pose a threat. You just have to have one that's capable. So if a model is capable of doing something better than humans, humans may not be able to stop it. So it's very important we figure out how to get it right as we grow these models right now. Colorado, I will say, I'm very proud of this state because we have the best law in the nation so far on AI regulation. And one of the reasons I like it is because it really does focus on interpretability. It focuses on testing your model, see what it's capable of. And that testing, that interpretability research, I'll make my pitch for policy here. I think that is the key to avoiding both these other policy short-term risks as well as long-term risks if they're important too, is just to understand them better. So when your legislatures and things come up for a vote, I hope people work in favor of more interpretability, more understanding how they work. And with that, I think I'm just about out of time. So have any questions came in that I should answer?
We do have a question that has come up, Colin. Thank you. We can talk about this all day long, I feel. But we do have a question that asks whether attorneys have to disclose to clients about use of generative AI to assist in research, assuming all rules are complied with, of course. But the question is, what is required and what is a best practice? And if you can give an example of a disclosure.
Sure. I am not aware of a specific requirement at this time. However, I believe the ABA Opinion 512 has some discussion of this. And generally, what I would say the best practice is do disclose you're using it. For example, what we do is we tell people we do use Lexis here. I'm not endorsing them. There's a lot of good tools. But we do use Lexis. And we do that because it is such a new technology. There are some lawyers who will get up here in these kind of discussions and tell you that you have an obligation to use it, because to the extent that it can save your client money, you kind of have to. I'm not sure if I go that far, but I do think you should explain to the client you're using it and why. So you say, here's what I'm using. Here's a short discussion about the guardrails. If you choose to not have me do it, I'll follow your lead. I get that it's new, but understand that that may increase your costs. And quick side note, don't forget about the Pricing Act that the legislature passed. That kicks in 3 weeks, I think, unless they moved it. And lawyers are covered there too. So you got to make disclosures to your clients about how you're calculating the bill. And if AI is part of that, you're going to have to put that in there as one of the reasons why you might not be able to tell them what that full price is up front.
Fair enough. Thank you for that. And again, we can talk about this all day long, but we're going to be respectful of everyone's time and let everyone get on with their day. I mean, before we do that, we do have to share the course ID and the fact that those folks who have sat with us and learned all of the wonderful information that you have shared with us are eligible for 1 hour of ethics credit and 1 hour of general credit. The course ID is 869934, and this is self-reporting, so you report it as you normally report. And just to close things out for us, just letting you know that you will be receiving copies of the presentation slides, and you will also be receiving additional information, those of you who have registered, about CLE reporting after the presentation. So be on the lookout for that. We cannot thank you enough, Colin. This has been incredibly enlightening, and I know all of us have enjoyed the way that you have imparted this topic. A lot of this topic can go over people's heads, and you have done a tremendous job at sharing it in a way that lawyers, non-technical folks can understand it. So thank you for that.
You're very welcome. It's been a pleasure.